What do fake bladders, robot arms, cannabis devices, nipple covers, and light fixtures have in common? They have all been protected, and sometimes hilariously dissected, by today's guest, Mark Hankin, one of the most respected, creative, and straight talking intellectual property attorneys in the country. Mark isn't just a lawyer, he's a translator between wild minds of inventors and the cold logic of the law. With a science background, a degree from UPenn, and decades in the game, he's the guy you call when your idea needs legal armor. He's been ranked in the top 1/10 of 1% of IP attorneys nationwide, competes with billion-dollar firms, and still finds time to geek out on lamp patents and the occasional Wizinator. If you're building something worth stealing and you don't want to get crushed by the copycats, you're going to want to listen close. Mark is not only brilliant at what he does, he's also one of the most entertaining people we've had on. Let's get into it. Mark, I just want to say thank you for jumping on. This is going to be a blast. I would just love to know, how did you get into what you're doing now?
So, I was really good in math and science. And so therefore I was told, go to medical school, be a doctor. So when I was 16 years old, I got accepted to the top half of the Ivy League in 3 medical schools, went to medical school, and I absolutely hated it. It was ridiculous. I don't know what the hell I don't like blood. I don't like bodily fluids. I mean, well, some, but it was really awful. So I, figured out, took a leave of absence, went into the wine business, eventually went into the family business, which was teaching. So I taught physics and chemistry for a few years, and teachers need summer jobs. So one summer I got a job as a paralegal at a law firm in New York City. They put me on a patent case. I didn't even know that existed, but all of a sudden I could do science, but not have to be in the lab, get paid like a lawyer. It was awesome. So I took the LSAT, applied to law school, and 37 years later, here I am.
That's so what are you finding as cuz you went from wine to teaching to law. Are there any kind of threads that you found that intertwine them all together?
Absolutely. It's interesting. I have a pretty big wine collection, and some people like to, play in the stock market. They buy low and sell high. I buy young and drink old. And the key to it is patience. And I've learned as a lawyer that a lot of times you can come right off the top of the bat. You can just shoot from the hip. A lot of times as a lawyer, delay, patience, cautiously thinking is going to be your best tool. Now, that's not always true, which we'll talk about a little bit later, but very much so, having that patience and really understanding that sometimes you have to just sit back and see how things develop is an important skill to learn.
Huh. I like that.
And then teaching, when you teach, you take complex ideas and you take these students who are completely unmotivated and maybe don't want to pay attention, don't want to listen. You have to break it down into bite-sized pieces for them and really give it to them so they can understand it. Well, when I'm talking to patent examiners or talking to clients or trying to maybe talk to the opposing counsel, or dare I say a judge or jury, I'm taking my clients' complex ideas, breaking them down into bite-sized pieces that everyone can understand, and explaining it in a way that people can figure out what's going on. So those skills really have translated through my whole career.
And how so we haven't had I haven't talked to anybody about this, and I'm sorry I'm jumping on this right away here, but what, like you said, in front of a judge and a jury, how often do you get to go in front of a judge and jury as a patent attorney?
Not as often as it used to be. When I graduated law school, there were very few cases going to trial. Since then, there's even fewer. So I used to go to trial. I used to try cases in presidential election years. About every 3 or 4 years, I was trying a case. And now these days, 98.5% of all cases in all areas, not just intellectual property, but 98.5% of all cases settle without a trial because it's just too expensive to go to trial. It's too time consuming. And then there's an appeal. In fact, on patent cases, the statistic is about 50%. Half of all decisions that judges issue in patent cases in the district courts get reversed in the appellate court. So basically, flip a coin. Who's going to win? And let's go up on appeal and figure out who really won. It's a hard way to advise clients to spend their money.
So really, the idea is settle outside of court, make an agreement that you all can abide by, and you win.
Yes. And the first step is to get good IP protection, which acts as a deterrent. to keep people from infringing you, to keep competitors away, and hope that you don't ever have to go to court. I love going to court, don't get me wrong, but if I always tell my clients, if we get to trial, you've already lost, because it's going to have spent a lot of money and you're spending your time with me in a conference room instead of being out there building your business, making products, selling products, and making money.
I definitely feel the same way about that. Luckily, I've not been in court over a patent law, but yeah, I definitely tell people, yeah, if you ever, not that I'm a lawyer, but I have had more than my fair share of time in a courtroom, and now we devise a system so we just have our clients basically satisfaction guarantee, pay if you feel like we did a good job. There's no more of that. So yeah.
One thing that I noticed, Mark, is, and you'd said this to me previously, is that you said that IP rights don't actually stop people from stealing. They stop honest companies from copying. Can you just unpack that a bit? Because I know you just kind of dipped into that a bit, and I'd love for you to unpack that.
Sure. So look, the laws exist to be enforced. But just like there's a stop sign and you could do a California stop and roll through it, or you could come to a full stop and then go forward, there may be a cop sitting behind that stop sign who's going to give you a ticket. But most of the time, you're on your honor to stop, follow the law, and move forward. Same thing with intellectual property rights. If I get a patent for a client, that patent's a piece of paper. It's a bargain with the government saying the government gives them the exclusive right for a period of years, 20 years from the earliest filing date, to make, use, sell, offer for sale, or import the patented product or process. But it's not like the government's going to be hiding behind the patent and come out of the woodwork and say, you violated the patent. You, the patentee, have to sue to enforce it. You have to send them a letter, send a cease and desist letter, offer them to take a license, threaten them with a suit, hire a lawyer like me to prepare a complaint and file in court. But it's not self-actuating. It doesn't just happen. You get a trademark, great, you have a trademark. I always tell people, nobody needs a trademark. The nice thing is, like a patent, it's a negative right. It gives you the right to stop other people from using it, but it doesn't happen by itself. So the innocent, honest, big companies that have in-house patent departments or IP departments, the companies that respect intellectual property rights, if they see you have a registered trademark or an issued patent, they're going to steer away from you. They're going to go copy somebody else. Infringers are going to infringe. Haters are going to hate. The thieves are going to come steal. You can't really stop them as easily, but you could move forward. I had this happen in real time this morning, where yesterday I spoke to a guy. Someone's infringing his patent. I said, here's what you do. You look, it's the all elements rule. You got to compare all of the different elements. And he emailed me early this morning. He goes, now I'm a little worried about this one element. You told me it's all elements, and look at this one. I don't know that they do that. Well, guess what? If they don't infringe all of the elements, they don't infringe. So he said, you know what? I'm not going to hire you now. I'll come back the next time I have a prospective licensee. So basically, I talked this guy out of sending a nastygram and potentially out of suing in a case that he would have lost, because I explained to him the law, explained to him how it worked. I didn't write his patent application. By the way, I would not have put a limitation as narrow as that in there. That's part of what we do at Hankin Patent Law. We review and make sure that we don't have unnecessary limitations, but his patent had an unnecessary limitation that is going to prevent him from stopping this infringer. The point is, I think that infringer read the patent and knew that by avoiding this limitation, they could get around it. So, people that are going to get around you, they're going to get around you. However, if you show that you have a nice copyright notice on things, you put a TM or an SM, or if you get a registered trademark or in a circle, if you get an issued patent, you put your patent number on there, those things act as deterrents to infringement. They help you stay out of court and make more money by selling more products or services.
Yeah, I really like that perspective you have on it. Because I think a lot of people think the patent is the end all be all for launching a product, and especially when you've got limited resources, it's really tough to watch people spend $20,000 when they've got $30,000 to get to market. And you're like, that's a tough one. But I think for the right people, it's definitely a great tool, and I've also seen the other end of that where that's allowed them to sell their product for tens of millions of dollars because they had the proper patent in place.
Definitely can help people make more money when done correctly.
Yeah.
I want to jump on something that you had said, because you had mentioned that and you kind of went through a whole bunch of different ways to solve an infringement problem. Can you kind of walk us through, because I can't remember them all, but there was licensing. You offer them a license and sue them, and you had like 5 or 6 of them. I was just wondering if you could kind of go through those for me.
Absolutely. So look, if you have intellectual property rights, be that a trade secret, a trademark, a copyright, or a patent, you own the rights and you can stop others from doing it. A license, by definition, is permission. I'm giving you permission to use it. I'm giving you a license. So one could offer a license to someone else to use your intellectual property rights. If you don't choose to offer a license, if you want to stop them, you could send a cease and desist letter. Now, a cease and desist letter is not required. You don't have to do it before filing a lawsuit. Again, it's not self-actuating. It's merely a threat. Sometimes I say it's, you're firing a shot across their bow, trying to slow them down and let them know that, hey, if you keep doing this, we may sue you. But at the end of the day, it's basically an offer. If you stop, we will not take you to court. Sometimes it asks for money anyway. Sometimes it says, hey, maybe we'll do a license. So you could come in hard and strong, stop. You could come in nice and kind. Maybe you want to take a license. Sometimes you just put a notice out there. Hey, look, we've got this going on. You should know about it, because you don't know which way you want to go and you want to see which way they want to go. And then sometimes we just ram right in there with a complaint. Let's go sue the guys.
Do you prefer one way over another, or is it all on a individual basis?
So look, I make more money if you sue and take it all the way. That's how I make a lot of money. But on the other hand, I don't want my clients going out of business because they had to pay me. So I want the way that's most effective. If a letter will get the person to stop, let's do that. If we can get them to take a license and pay a royalty, let's do that. If we can get a cooperation, let's do that. But if we can't, I'm fully prepared to go in as hard and charging as you want me to. It's just it's amazing to me how few lawyers seem to ask their clients, what are your goals? What do you want to get out of this? That's one of the first questions I ask. Sometimes I say it explicitly. Sometimes I'm just listening implicitly. But what do you want to happen? A lot of times I'll say, okay, they told me their story and they just go on and on with their story with more facts than I want to hear. And then I'll say to them, okay, what would you like me to do? What would you like to hire me to have happen? And it's amazing how many people have not thought about that. Do you want a license? Do you want to stop them? Do you want money? Do you want recognition? And when you figure out what your goal is, now you have a path towards that goal. So it's important for me to understand what my client really wants so that I'm driving in that direction. It's like getting in the car to go somewhere. If you don't know where you're going, where do you drive? Do you get on the freeway, you go south, you go north, you get on the local, like you have to have a destination in mind. I have to know what you want to happen here. But you can always escalate later. You can always get tougher later. But it's nice to have a path to know what you want to happen and then move towards that.
I would love to, like, what do investors, because we had talked about licensing, and I know that in licensing, a lot of investors are looking for, what can we license someone else to make the product? What is it? What kind of patent details are investors looking for in the licensing, in a patent or in a product?
It's always funny. People with money want to come in and they want to know that they're investing in something that's actually worth something. So a lot of times the number of patent applications or trademark applications that you have is important. Sometimes having a registered trademark or having an issued patent is important. But in my experience, a lot of times investors don't really understand how to evaluate the strength of the intellectual property. Is it valid? Look, it's presumed valid by statute, but is it really valid? Is it going to stop the infringer? How broad a protection is this? I used to work with a guy. We shared a wall and a secretary, and he used to say, I can patent anything. I bet you probably could patent anything if you went narrow enough and so many limitations and so much restrictions. You probably could get a patent on literally almost anything, and you couldn't sue a soul because no one would ever do all of those things in that narrow patent. So what good is it? I tell my clients, don't spend the money with us to get a patent if you're not willing to at least threaten to file a lawsuit. Because if you're not willing to enforce your patent, why bother getting it? Save your money, do something else. And, you know, at HPL, one of the things that we do, I talk clients out of spending money with me a lot. There's often times where I say, yes, you can do that, but should you do that? Is that the thing to do? You don't need to do that because sometimes it's not the right thing and maybe their goal is different and it's not going to accomplish their aims. So why spend money with a lawyer if you don't have to?
Yeah, that's I really just you're such a refreshing viewpoint on patents because we talk to a lot of patent attorneys day in day out. We have clients talk to a lot of patent attorneys, and man, like some of the stuff that we get, it makes it tough to move forward because they go right into the patent attorney or the patent before we even work on the design, and then they don't want to improve the design because they don't want to lose their patent. And everyone's sitting here telling me that the patent is like why they're like when do you think it's the right time to patent something?
Brandon, that's the key question. People sometimes wait too long. I had somebody on the phone yesterday. They had the most incredible thing. I loved it. And they started selling it 4 years ago. I can't help you. You have up to 1 year from the date you first sell, offer for sale, reveal, disclose, publicly display, and you can't file a patent application after that. It'll be invalid. So I always tell people it's better if you go to the intellectual property attorney sooner than later. They might tell you to wait and come back, but if you come too late, there's literally nothing they can do to help you. So when my clients come to me or my prospective clients come to me, I always say, look, let's look at what you're doing. How far along are you and what do you plan to happen? And yes, you mentioned, well, if you have $30,000, how do you spend $20,000 with a lawyer? Sometimes the initial spend on intellectual property is the most important of all because you're protecting yourself before you've disclosed and before someone else can rip you off. Now, with trademarks, rights in the United States come from usage over time. So the longer you use a trademark, the stronger it is. So I don't care if you use it for 5 years, 10 years, 20 years, as long as you want, no problem. On patents, if you wait more than that 1 year, I just can't help you. So it's important to get in there early. The United States is a first inventor to file system. The first inventor who files a patent application wins. In the old days, it was the first to invent. And so sometimes you had some big company that would rush in with a patent application, and some guy was tooling away in his garage and in his basement, and he's inventing stuff. I always wanted to stand in front of a jury with that letter with the envelope where the guy is signed on the seal and the postmark shows the date, and we rip it open and show that he had the invention as of that date. I'm never going to get to do that because that's not the law in the United States anymore. It's not who's the first to invent. It's who's the first inventor to file. So they used to call that a poor man's patent. And I still have people asking me, well, can I do a poor man's patent? Yeah, you can do it, but it won't make a damn bit of difference. Is it going to help you? But you can do it if you want.
With the trademark side, you said it gets stronger the longer you use it. Do you have to file to have trademark rights, or can
Not in the
you
United States.
I'm sorry, say that
Not in
again.
the US, No, you
Okay.
don't have to. But again, it's better to file. Look, I'd rather represent the client who has the trademark and somebody else is infringing than the client who says, well, I've been using it for 27 years, but you got a trademark 2 years ago. So I've had that happen where somebody's come out of the woodwork after we got a registered trademark for a client and somebody else came out and said, well, I've been using it longer. Use in the United States is what matters. So again, it is better to file early, but it's not as essential with a trademark where it's absolutely mission critical with a patent.
Gotcha. That's good to know.
Do you have any examples of any of the projects that because I know that you've worked with tons of projects over the last 27 years. Do you have any examples of someone who like did it right and really it worked for them, or someone who didn't do it right and you were still able to save?
Well, doing it right. So I think my favorite project ever was actually a copyright project. I had a client that was a patent client of mine, and he and his business partner had all sorts of innovations. They were really creative. one of the two guys, one of the guys was a world famous artist, and he painted in the style of the old masters. And the Northridge earthquake in 1994 destroyed a lot of buildings in Los Angeles, including the cathedral, the St. Vibiana's Cathedral. Archdiocese of Los Angeles has more masses in more different languages than any other archdiocese anywhere in the world. It's a huge archdiocese, and they have great people and wonderful things, but all of a sudden their facility was damaged beyond repair. It's now a restaurant, by the way. But they built a brand new, gorgeous cathedral. And where else? On Temple Street. Gotta love that. And they built this beautiful building with thin alabaster walls. So there's no windows. The light comes in diffuse, streaming through these alabaster walls. Well, you guys understand how rock works, right? When you got sound in there, and they got this gorgeous organ, bing, 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 sound is bouncing off and you can't hear anything. So they realized they had to line the walls with something that would deaden the sound. I got an idea. Why don't we make some really cool tapestries? So the Communion of Saints was born, 125 different saints. And my client was the one who created them. And he and his business partner figured out how to get these tapestries woven. They were actually woven at a looms in Bruges, Belgium, where they're famous for making amazing tapestries for the last few hundred years, or maybe more than a few hundred years. But the technology was brand new. So if you ever go to the cathedral, there's some gorgeous doors made by oh my gosh, and the doors are not protected, and the fountains by Lita Albuquerque are not protected. But all of these tapestries, we got copyrights on them. Now, it was interesting because there was a budget for the entire project, and legal was about, I don't know, about 2% of the budget, and we were at about 98 to 99% of our legal budget before the project really got underway. And the head, the guy, Brother Hilarion O'Connor, who was the head engineer, the head architect, dealing with the architects and the engineers and the builders, and he was the contractor for the archdiocese, was all upset at us, being like, why you've spent all your budget? Yeah, because we have to do this early on. So my client kept the legal rights, kept the copyrights to all of the images. And some of those images sell very well in the gift shop. And every time they want to sell those images, my client is the copyright owner. Now, I think he's given a little bit of a deal because, of course, it's the archdiocese. Why not if you're a good Catholic? But the fact is he's kept those rights, which will last for 100 years when others did not get to keep their rights. So that was a really cool project, and we negotiated for that, and it was awesome. The archdiocese brought in a lawyer from the Getty Trust to go up against me, and we still got a really great deal for our clients. So it was important. It was important.
You don't think of lawsuits in the church too often, but that's really interesting.
One of the biggest supporters of architecture and art in history. They have a lot of money to spend, and they spend it to support artists. And they've built a lot of beautiful things over time.
Makes sense. It's interesting that you're talking about copyright and not, you did that through a copyright, not a patent. Can you explain why that was the case, where you copyrighted that versus trying to go for the patent?
I tried to convince my client to patent this. So he and his business partner had this amazing sound dampening system. And the way the tapestries were hung. So look at it this way. I told you earlier, patents last for 20 years in data filing. Trademarks last for 5 years, then you can renew for another 5, then 10. You can have trademarks ad infinitum if you keep renewing. Copyrights, life of the author plus 70 years or 120 if it's, the corporate. So it's for a limited time. But tapestries, they last hundreds of years. I don't know if you've been to some of the great cathedrals of Europe or been to the cloisters in New York City where they have tapestries that are, 300, 400 years old. Tapestries last a long time. And so if you're going to make them, you want to, first of all, make them high quality. And second of all, the protection should last as long as it can. And then, how do you do this? So it's not just the front, the image on the front, but the sound dampening behind it was really creative and novel. And I thought we should get a patent on it. The client didn't want to. They figured that was something they were going to sort of donate to the public and not spend the time and money to get a patent on their system, the system of hanging it, because these were hung in a special way. They work in a certain way. And then, of course, as an afterthought, he ended up having to do tapestries for the front and the back. And the front's really cool. It looks from a distance like concentric circles, but if you get up on the altar and go look closely, it's actually a map of the city of Los Angeles with rivers and highways. It's really cool. And the back one is the bestseller, or at least it was anyway, last I checked, bestseller in the gift shop. It's John baptizing Jesus, and it's about 42 feet tall. I watched them build the baptism pool. It's basically like a picture a hot tub lined with lead, but it's incredible. And it's over the St. Vibiana Cathedral, St. Vibiana Chapel. And down there, that you can get buried down there. If you have a lot of money, you can buy a crypt to get buried. It's kind of a cool building. I was going around with a hard hat and walking on the subfloor. I could give tours. Nice Jewish boy from New York could give tours of the cathedral because I was hanging out there during the building. But I wanted a patent. I wanted to get a patent, but we didn't try. But copyright on the images, that was the best way to protect it. And actually, that's turned out to be a pretty successful thing. It's fun, I represent creative people, and their creativity should be protected. Sometimes the key is, sometimes it's a patent, sometimes it's a trademark, sometimes it's a copyright, sometimes it's a combination of 2 or 3 of those, because they protect different aspects of the creation. And so not everything, so sometimes they say if all you have is a hammer, everything looks like a nail. I train my people to be cross-trained to understand that there's many different ways of protecting intellectual property. There's different aspects to it. And don't just assume that one way is the best. Patent is very strong, but in this case, copyright was going to give them longer protection. So that was a way to go. And you mentioned trade secrets earlier, Joel. I always ask this question, and nobody ever gets it wrong, but I don't want to embarrass you. The most famous trade secret in the United States is, can I say it?
Coca-Cola.
Nobody gets it wrong. Say it. Formula for Coca-Cola, right? It's known by 2 people. It's kept in a vault in Atlanta, Georgia. They let you buy local water and local carbon dioxide, but they ship the syrup out of Atlanta all around the world. That Coke syrup is the key. That's the trade secret. If they would have got a patent on that, the patent would have expired by the end of World War II. They've been able to keep that trade secret for 100 years more. And that's because they kept it, again, knowing which way to go with protection, that's the key. See, at HPL, our motto is measure twice, cut once. We think about, what are we trying to accomplish? Let's figure it out. And before we jump, let's make sure that we've done it correctly, where we get the protection that the client really needs. Look, they come to me all the time. I want to patent my slogan. I want to trademark my way of doing this. Clients don't know. By the way, lawyers don't know. I deal with general lawyers, they may be specialists in a different area, but they're not IP lawyers. They don't know the difference between a patent, a trademark, a copyright, a trade secret. And understanding those differences, that's why you hire a specialist.
Exactly. Yeah. I've definitely found that lawyers are a lot like doctors, where most, no one doctor is an expert in every part of the body, right? Like it's a very, very, very big field, and you gotta really go to a specialist. And it seems like you're definitely one of the best in your field as well. So you're a specialist among specialists.
It's funny. You can't believe your own BS, right? Don't believe your own publicity. But what I love is the fact that there's regional, national, international surveys that have ranked us consistently. We've had the firm 21 years. I've been doing this 37 years, but we've had the firm 21 years, and we are consistently ranked in the very top. I don't think we're the best firm in California, but we get ranked as the best patent firm, best copyright firm. I testify as an expert witness, and I've been ranked as Joel was saying earlier, I've been ranked in the top 0.1% of trademark lawyers in the United States by Patexia. They analyze data from the Patent and Trademark Office, and they compare all the lawyers out of tens of thousands of lawyers that they analyze and evaluate. We've been ranked in the top 1% of patent lawyers. Actually, right now, currently, we're 1.6% of patent lawyers, so technically in the top 1.5%. But anyway, but the point is that we get ranked. We get ranked by Chambers, which is the top 2% worldwide. And, it means to me that the good work we do for our clients is being noticed by people, that there's some empirical statistics you can look up and say, okay, these people are not just filing a lot, but they're doing a good job. They're getting good results. Their yield is successful. And that's why people can hire us in confidence, knowing I've been a super lawyer since they came up with that back in 2004, or whatever it is. And I love going to the super lawyer event and seeing all the other super lawyers. And like you say, Brandon, people are specialists in different areas, which is kind of fun to know, because I refer a lot of matters out. I like to know who's the best divorce lawyer, who's the best real estate lawyer, who's the best corporate lawyer. But if somebody wants to come to a really good IP lawyer, a lot of companies and evaluators think that we're amongst the best, which is kind of reassuring that what we're doing is working.
So, our curiosity, is there a place that we can see, like, where they list like the super lawyers?
Sure, you can go to the super lawyer's website. For chambers and chambers, for chambers parties, you can go to chambers. There's all Petexia has these. They actually look. They're in the business of collecting, analyzing data, and selling it. So they have reports that you can buy. But I buy the reports because, first of all, I want to see myself. Second of all, I want the proof in case anyone says, "Well, I don't believe you're that." Oh, here's the proof. But more importantly, I look at my opposing counsel. I look at my friends and colleagues. It's kind of funny to see that people I've known and respected at law firms that are much better known than our firm. We have 5 lawyers and 2 paralegals. We're a small shop. But firms that have hundreds of lawyers, where the people get ranked lower than we, I always laugh at that. And it's kind of cool to see where people are ranked. But yeah, this is all publicly available information. This is not somebody's opinion. They vet these things. I never do pay to play where you just buy an ad and they put you on a list. That, to me, that's just nonsense. These are all carefully analyzed. In fact, I've been for many years on the blue ribbon panel that evaluates super lawyers that have been recommended. So somebody gets recommended, and then I go in there and I say whether I agree or not. We look at their statistics, we look at their resumes, we look at their background, we know their reputation in the industry, this sort of thing. So it's a little bit of marketing goo-gaw, but on the other hand, I'd rather be in the 5% or the 2% that is than the 95% or 98% that isn't.
For sure, I agree. I mean, it's the very relevant speaking to you. And we speak to a lot of great attorneys, and there's nothing against the other ones, but
No.
very few of them have ever given your perspectives. And I really like how your first question is trying to figure out what it is that they want to accomplish. Far too often in all industries, I think that's overlooked. It's like, here's my hammer, let's drive in a nail, And it's very easy. You spend years, decades, sometimes training to drive a nail, and you're really good at driving a nail. You want to drive as many nails as possible. But to be able to take a broader approach and say, maybe we need to, I don't know, run some wire, whatever, and
yeah, take a step back and figure out, it's not just a matter of driving the nail. Where should the nail go? And by the way, should you put the nail? Do you want to put the nail in that piece of glass because you might break it? So sometimes it's better to sit quietly and not do anything. And that perspective, as I said, my patience in wine collecting has taught me patience in the law. Sometimes sitting back and not doing something or not attacking somebody. Sometimes I'll tell people, don't file a trademark because what you're doing, I don't think infringes these other people. But if you file a trademark application, you're putting yourself out there publicly, you're getting on their radar, and they might come after you with an infringement suit. They might think you're too close to them. So by your filing, nobody needs a trademark. By your filing, all you're doing is saying, here I am, come get me. That's a bad idea sometimes. So getting the perspective, and again, one of the greatest services I can provide my clients is telling them when not to spend money with me, when not to do something. And I'm proud of that, because I do sometimes look at things, I'm like, well, other than the lawyers making money, why are they doing this? And that's a bad look. There's 2 kinds of lawyer jokes: the kinds you people tell, the kind we tell. Ours are funnier. So I'm just going to say this: 75% of lawyers give the rest of us a bad name.
I love it.
I like it. I like it.
I love it. So let's bring it kind of back to the questions I had here. A lot of our listeners are actually early stage startups. They're basically just trying to build their product now. And so they haven't talked to you yet, or maybe some of them have. I don't know. But what is the most cost-effective way to get protection started?
Sure. So, as I said, it's really important to talk to an IP attorney, whether it's me or someone else. Talk to an IP attorney as early as possible in the process. I love startups. I love companies that are just getting going, and IP is their biggest asset. If you can file a non-provisional utility patent application on your product or process, let's do it. but it could cost $10,000 or $15,000 depending on what it is, and it could take a couple years. So let's look at the whole picture. Should you keep this as a trade secret? Are there copyrights and trademarks that you could file which are less expensive and you could get them quicker? Can you file a design patent application? Because that's usually 3 to 6 to 9 months, sometimes longer, but typically faster. Do we want to file a provisional patent application? And I got to tell you, I have people come to me all the time. Oh, I got a provisional patent. Um, what do you mean you got a provisional patent? Well, I went to LegalZoom and they took care. Okay, look, first of all, there's no such thing as a provisional patent. There's a provisional patent application. And you didn't get anything. No person at the patent office ever looked at that or examined it. All you did was file a piece of paper. And by the way, if you go to LegalZoom or companies like that, a lot of these mills, they're owned by lawyers. They just don't provide legal advice. And they'll file. I've seen what they file. They'll literally give them a half page of text and they'll file that and say you have a patent application on file. I'm sorry, but that isn't working for me. And it isn't going to work for you if you ever try to do anything with it. Of course, you can't enforce a patent application. If you file a proper non-provisional utility patent application, and when it gets published in 18 months, because it's kept confidential the first 18 months, when it gets published, if somebody's infringing and you give them notice of that by sending them the published patent application, when you eventually get a patent, patents issue on Tuesdays, when you eventually get a patent some Tuesday in the future, you can file a lawsuit that day and seek damages back to the date you gave actual notice. But you cannot sue on the patent application itself, and you can't sue until the patent's issued. So taking these other steps, be it copyright, be it trademark, be it design patent, taking these other steps are going to help you along the way and give you something you can use to stop people. But at the end of the day, until you get a proper non-provisional utility patent issued by the government, you really can't stop people from making, using, selling, offering for sale, or importing that product. So layering your protection is important, having multiple applications on file and having a continuation application where you can maybe come after somebody later. All of these things are important down the road. But for a startup who doesn't have a lot of money and can't do everything, it's hard. I say, let's look at it. Let's figure out what it is. Let's not go more than that 1 year, but maybe filing a non-provisional patent application is the best thing you can do. And maybe you file some other things first and see where it goes. But it's hard for startups because that 1 year is non-extendable. So a lot of people end up filing provisional patent applications. And the problem there is, why are they less expensive? Because you're doing less work. You're leaving stuff out. So what do you feel comfortable leaving out of your provisional patent application? What do you feel comfortable not filing on? And then there's the people who say, well, I drafted my own patent application. Will you just file it for me? Yeah. Rarely ever are those something that I will put my name on, because if you haven't drafted, I mean, we've done thousands of patent applications. If you haven't drafted at least a few patent applications, really you don't understand what should be in there. You can make it look like one, but the key is to have the right things in there. And more importantly, like with this guy this morning, not have unnecessary limitations in there. So I say to startups, listen, I don't care how great your idea is. I don't know how much you're going to sell this, but if you can afford to file a patent application, let's do that. Now, we can file international. There's something called the Patent Cooperation Treaty. We can get you patents in 150, or patent applications anyway, in 157 other countries outside the US for a small amount of money. We can, move things down the road. We can always file more patent applications later. But in my opinion, the key is to file that first non-provisional utility patent application here in the US to protect yourself in the biggest market in the world.
And just to be clear, you can file as many different combinations as you want. You can have a provisional, you can have a trademark, you can have a copyright, all going at the same time. You have multiple provisionals, right? Like there's no limitation on what you file in the order that well, maybe some on the order, but for the most part,
order matters a little bit, Brandon. But yes, you're right. You can protect different aspects of your property, your different aspects of your intellectual property with copyright, with trademark, with patent. You might keep some things back as a trade secret. Here's what you can't do. You can't file a patent application and hold back some of how to do it as a trade secret, because there's a requirement in the United States that you disclose your best mode. So you have to tell us if you're going to file a patent. The deal with the government is we give you exclusivity for 20 years in exchange for you teaching everybody else how to do it. Now, remember that famous quote from Sir Isaac Newton: if I see farther than others, it's merely because I stand on the shoulders of giants. And that's how the patent system is built. The patent system is built that you disclose your invention. So Stanford discloses its stuff, UCSF discloses its stuff, UCLA discloses its stuff, and then all of a sudden, somebody out in the Pomona colleges, they can look at this and say, oh, Claremont College, we've got this great invention, and all these other people, these big institutions that file so much, we're going to take it farther. We're going to do research and do something different. Well, the key to that is by disclosing how the thing is done and your best mode, then you've told everyone what they need to know. If you try to withhold that as a trade secret, that doesn't work. You can hold as a trade secret things and not file a patent on them. So maybe part of what your business does is a trade secret, and part of what your business does you'll file a patent application on. It's just you have to know where those lines are drawn. And then again, the branding, the trademark is important. The copyright often is important, especially with computer software. U.S. government screwed up in 1980. The Supreme Court had a case, and they decided to allow patents for software, which is great. The problem is they probably should have done what they did with semiconductor chips. I don't know if you're familiar with semiconductor chips and what they call mask works, but they came up with a sui generis protection. Pardon me, sui generis protection for semiconductor chips, because you could basically put one of those things on a photocopier and blow it up and then just lay your wire, and you literally are copying the chip. They should have come up with something for software, because patents don't really cover it and copyright doesn't really cover it. If you write something I used to program in Fortran and COBOL, but these days it's C++ or Python or whatever. But if you put something in C++, somebody else could put it in Python. Arguably, that's not a copyright infringement. It's a translation, and you can make the argument, but it really isn't copyright violation. And then if you get a patent on it, patents are hard to enforce for software. So we'll tell people, look, give us the graphical user interface. Show us what the user will go through using your software. Let's take the different steps through the GUI, the graphical user interface. Let's make screenshots of that, and let's explain to the patent examiner how the software actually works. Well, then let's take those same things and file them for copyright. And the key is, because you don't want to disclose before you file your patent application first, file your copyright application second. And by the way, copyrights have a time frame also where you can always file later, typically about 5 years. If you file a copyright application within the first 3 months, either before publication or the first 3 months after publication, you can get statutory damages and attorney's fees. So you can come after somebody for up to $150,000 without proving that you would have made those sales, and your attorney's fees, which is why there's a lot of copyright trolls out there going around policing the internet, saying, oh, you used my picture on the internet, and I filed 786 pictures all at once, but you used one of them, so I want $10,000 when you wouldn't have paid $5 for that picture. Happens all the time. But if you file early for copyright, you can get some really good teeth. So the key is, if you're a startup, if you're a small company, talk to an IP lawyer, find out what your options are, see what you can afford to do, and don't just assume you can't do anything. More importantly, don't just assume that there's only one thing you can do, because there's other ways to protect what you have. When people come to you to make products, sometimes they've thought about it, sometimes they've protected it, and sometimes they just don't know. And you're going to improve their products for them, right? Sometimes you're going to come up with things that make it better than what they had in their mind. And planning these things out, thinking them through, looking at where it's going to go, that's what makes a successful business, in my experience.
Wow. I think you hit almost all of our questions just in your conversation. Like, it's fun to listen to, because even though you like, it's been so much fun listening to you, but you said, like, I had questions like, have you ever helped inventors figure out when something's actually patentable? And you literally just said that. And I'm like, oh, okay.
Sorry, Joel.
Well, yeah, you basically took my whole outline and just threw it all out. No. No. So, what products have you seen that you saw because of patents, they really, really thrived?
So it's interesting. everybody thinks about, like, I mean, just look around your desk, think about all the things. You got a stapler, you got a computer, you got a cell phone, you got all sorts of tools and equipment and things. Pens, the way, I've worked on pen patents. I've done a lot with shoes. But, we all walk, right? Well, God willing, we all walk. There's so much technology that goes into shoes and feet. I've represented all sorts of shoe companies and worked on the heel cup and the tongue and the mid, the sole and the way. There's so much technology in there. But what's interesting about it is that sometimes it's the weird, unusual things you never even thought about. So I don't know if either of you have ever driven a truck or an RV, but a lot of them have air brakes. And when you're parked, you have a brake, and you basically lift the brake up. You pull the plunger up, and it activates the brake. And to take it off, you push it down. Well, if you've got kids or pets, or you're just maybe not paying as careful attention as you should, you could accidentally take that brake off. So if you're attached, you've got your RV attached to some hoses and plugs, and you're tied into the wall, and you take that brake off, you start rolling back, all of a sudden you rip the crap out of everything. Well, I had a client who came up with a really simple, like a little cuff, and you put the cuff around the pole, and it protects the top of the stopper from the bottom, and you can't accidentally take the brake off. And then you could put a lock on that. So for kids and for theft and for whatever else, your dog's not going to jump up there excitedly and plunge it down. And this little cuff sold, and they sold lots of these. And it was an incredible invention. We patented it for them. We got trademark for them. And it was remarkably successful. It's incredible. I think my most successful client ever was somebody, I don't know if you ever drive on the 5 down to San Diego from LA, but eventually you get into an area where there's a military base, and it's sort of, desolate foliage to the left, and to the right on the water side, sometimes you see these little grayish buildings. They're doing training exercises. And if you think about it, when you want to train military or police or first responders to go into an area, maybe an urban area, you have to go in, you have to figure out who are the hostiles and who are the citizens. Who do we not want to shoot at? Who do we want to shoot at? And what do we want to do, and how do we want to approach this? Well, if you have to set up a little town and then you go in there and shoot the crap out of it, you got to come back and rebuild it. I've got a client that has figured out a way to make buildings that basically you can shoot through and they don't get destroyed. It absorbs the shock and takes the bullets. And so we're not talking about blanks. We're talking about real bullets here. But basically, you don't have to rebuild the buildings. And they came up with this. And they licensed this to the U.S. military and to police agencies all over. And it's the greatest thing. And every time I drive by, I'm like, I protected that. That's pretty cool stuff.
That's awesome.
There's
That's so much
technology
fun.
in everything. Yeah. There's all kinds of cool inventions. And, people say to me, well, I, have this brilliant invention. I love brilliant inventions. I love the next $1 billion, whatever. But I can't remember the last client that came to me that didn't have the next $1 billion invention. What I like are the people who have these small incremental improvements, or things that are, solve a problem, like not releasing your air brake, or, how do you train people to shoot up buildings without destroying the buildings? It's amazing the problems that people solve. And, I always tell people, look, a patent application answers 3 questions. What problem are you trying to solve? What have others done to try to solve that problem before? And why is your solution better? Is it less expensive, more elegant, yields better results? What about that? And if you can explain those things to me, I can explain that to the examiner, and we can get you a patent. And so when you think about all the problems in the world, and there's a lot of problems in the world, and you're going to solve your problem that you're dealing with, your solution should be more elegant, less expensive, yield better results than what other people have tried to do with that. And when you approach it that way, all of a sudden you have something that's not only patentable, but marketable and can make you money.
Now, I have a question about that. What if you take a concept that's already used, like a couple concepts that are already working well individually, and you put them together? Is that something that patents well, or is that more difficult?
Brandon, I only write with 26 letters. It's the combination of old things into new things that matter. So you take old inventions, things that exist, and you figure out how to put them together in a more efficient, effective way, and that can be patentable. So, you're not I mean, look, there are people who are inventing new elements. They're discovering things that never existed before. They're creating new, but for the most part, inventors are taking things that exist, the old things, putting them together in new ways, new combinations, and then protecting that new combination. I represent a company that makes bicycle racks, and we've gone up against some of the biggest bicycle rack manufacturers in the country/world. But look, when I was a kid, I rode a bike and we put our bike in a bike rack. They've existed a long time, but there's always some new way of doing a bicycle rack that is different from what other people have done before. We do a lot of robotics, and robotics are typically a way of making something that you could do yourself work in a more automated, simple, maybe repetitive way. And so you're building a robotic that does something over and over and over again with precision. There's nothing new about the thing. It's the way you've used the tools, the pulleys, the levers, the centrifuges, whatever it is that goes into this robotic thing to do that. Um, we do a lot of food and beverage and dietary supplements, nutraceuticals. Protecting those is difficult because a lot of these formulas are out there. There's a lot of homeopathic recipes and combinations. But looking at the way things get combined and figuring out, is it new? I've got a woman who's a menopause expert. When she was in her early 40s, she went through early menopause. She actually got married after going through menopause. So she had menopausal bride, and now she does the menopausal makeover. Well, she's come up with some food products that people can eat. She calls it Eat Like a Woman. And the three of us probably wouldn't be that interested in these products, but for women who are getting older and need more supplementation, she's got some really great recipes, really great formulations. And some of these are actually, I think, patentable over what's come before because she's done the research and she's figured out how to make these things successful. And so working with clients and figuring out what pieces are old, what have you done in a new combination, and is that new combination potentially new, useful, and not obvious, and therefore patentable? And to me, that's the fun of the job. I mean, I love doing this stuff. People say to me, well, you work on anything that's cool? Everything I do is cool to me. I mean, my clients love it. We patented uh, many things for many people, but sometimes the copyrights and trademarks are fun. We just did a game for somebody created a game for kids with interchangeable animal figures. I'm working on another game right now that may or may not be patentable, but certainly we could protect with copyright and trademark. And it's got kind of like a little console to it. There's all kinds of cool things that I work on that are just new combinations of old things that are taken in a different direction, and they're fun, they're exciting, and it's interesting, and more importantly, the inventor can make money from it.
We have a client right now that I'm meeting with next week. He's actually coming to me to talk about specifically making a board game. So that's really good insights. Yeah.
Yeah. Yeah, games are fun. I love playing games, and some of them really are novel. A lot of times it's copyright and trademark because, look, if you think about Monopoly, you got a board, you got pieces, you got cards. I mean, there's only so much that you're innovating from a patentable standpoint. But trademark and copyright are great ways to protect games. Now, we had one. I had a public school teacher who happened to be a lesbian who came up with a game that had it was pimps and hoes and all, and she didn't want her name associated with it, so she used my name and used my address, and we filed the thing under the company name where we kept it confidential. But it was a really cool game, and the way you played it was really cool, and we got protection for it. It was awesome.
It's
And
awesome.
one day we were in the office. I don't remember what happened, but
Can you see
maybe
what
the
the name of the
internet
game
went out.
is?
Yeah, it's I think it's called Pimps and Hoes. But anyway, um, the internet went out, and we had nothing to do until the internet came back on. We pulled out the game, we played it on the conference room table. It was kind of fun, just like playing a board game. But the point is that there's all kinds of creativity, all kinds of neat things that go on. Um, so
Yeah.
That's awesome. That sounds super fun.
So
yeah,
we're running a little bit to the end of our time, but I wanted to go through a lightning round with you.
okay.
We're just gonna ask you. I've got 4 questions because I used one of them because you stole all my questions. Um, but I'm gonna ask you 4 questions. We're gonna go kind of for a quicker response, but if you want to elaborate, feel free. All right. So, what is the coolest invention you've seen this year, and why?
Boy, I've seen a lot of cool things. Um, I shoot. I, uh, I have a client who has a medical device that can test for certain genetic uh, things. And you use this to figure out whether you might have a predisposition towards certain kinds of cancers. I don't do a lot of pharmaceuticals or biotech, but this one was really neat and could be life saving. It could really be life saving. And so we're hoping that we're going to be able to get the protection. They're going to be able to go out and use this and market it. I want it because we're all getting older and we all are worried about all the kinds of things that happen to us. And there's a lot of competition out there. So I think some of those are the cool ones. Um, anyway, everybody has an AI invention these days.
I am inventing an AI. No, I'm just kidding.
Everybody is.
So, what is the biggest IP mistake that startups make that you see?
It's what we talked about earlier, waiting too long. If you wait too long, because you're afraid, you don't want to spend the money and you don't even want to find out how much it's going to cost. So you wait too long, and then all of a sudden it's been disclosed and you can no longer protect it. That is the biggest mistake. If you have something that's really great, talk to an IP attorney as soon as possible. If they tell you to come back, that's fine. But if you wait too long, they can't help you.
Yeah, one of the biggest things that we've seen in working with entrepreneurs is the paralyzing fear, where they just don't want to do anything. They're like, I really want to make this product. I really want to make this product, but I don't want to spend any money, and I don't want to actually. And if I start going forward, I think the fear is if I start moving forward, I'm going to find out that this has already been done before, or that it's not as novel as I think it is.
Right. And that happens. That does happen.
Yeah. So, what is one piece of advice you'd give to every inventor?
Don't disclose until you're ready. People always want to talk about what they're working on, and they pull NDAs off the internet. I know we're in the lightning round, but very quick story. Guy had an invention. We got a patent and trademark for him. Calls me up one day, says, "Oh, somebody's copying me. They're violating our NDA." So I don't remember doing an NDA for you. He goes, yeah. Well, I found it on the internet. Let's look and see what they're doing. Well, he had a patent and a trademark. So there's nothing confidential about his thing. But the guy who was copying him took his idea and went ahead without him with a different way of doing it. So our NDA that we give our clients has very strong non-circumvention clauses. And it's not just a matter of not disclosing confidential information. It's I'm going to show you a way to make money, and you can't go out and use that and to circumvent us. That's the critical part of it. It's not a matter of using my confidential information. It's a matter of taking my business idea and going out and competing with me. It's not a non-competition. It's just a non-circumvention. You can't take this. I'm bringing you to the table. You don't get to go forward without me.
That's an interesting. Yeah. Now, do you think like a lot of our clients, they'll say, "Hey, we don't want to talk to you till we get our patent done," or, I mean, I guess what I'm saying is like, can your clients share their ideas in a safe way without having to do a patent, or is there other safe ways to get their ideas out to the professionals without publishing it? You're right, because you might want to get some feedback on is this manufacturable? Is this feasible? Can we do any kind of case study or marketing studies on this without investing on the patent side?
What do you mean by safe? So so here's the thing. Just like a patent's not self-actuating, the best agreement is a handshake between people that you can trust. I can write a 30-page agreement, and if you violate it, I still have to sue you to enforce it. So we have a really good NDA with strong non-circumvention provisions. I recommend all my clients use it before they disclose to somebody like yourself. No offense to some. They always hire software developers without properly protecting themselves. They talk to the money people, and I've seen the money people steal ideas. I've seen developers not give the program. I've seen all kinds of deals fall apart. I've never seen you guys do anything wrong, but there are people out there that will violate these agreements. And unfortunately, you can't, you can't say, well, you signed an agreement. You have to actually sue them. But if your version of safe is having some legal document I could sue you for breach of contract, then yeah, I would say have them sign an NDA. And here's my view on it, Brandon. Even if an NDA isn't airtight and not self-actuating, I view it as a litmus test. If they sign the agreement, they might still rip you off. But if they don't sign the agreement, they're absolutely 100% going to rip you off. So it's your choice, but I would say let's have them sign a non-disclosure agreement with strong non-circumvention provisions. Let's let them know the IP is yours and you're not transferring it. And if they sign that, they're just much less likely to steal from you.
So we have a little different take on this, and I'm kind of curious to get your perspective. We have an NDA that we send out to our clients, especially if they ask for it. It's pre-signed, goes right out, no issues with saying our NDAs. I don't sign anybody else's NDAs for the simple fact that I'm not an attorney, and I literally talk to, I don't know, maybe 5 to 10 people a week, and I have no way to vent, or nor do I want to get into the legal discussion, because we used to go back and forth. Before we had this policy, I had clients that go back and forth 3-4 months on an NDA, never do any business with them. Probably doing some consulting with an attorney charging me, hundreds of dollars an hour. So after a scenario like that, we just said, hey, look, not everyone's a good fit for us, and we understand that. What I would like to do is kind of find that, I don't know, I'm open to suggestions to how to make a fair thing to not get ourselves in any trouble, not spend a ton of resources with people that haven't made a financial commitment to us. And then also give people that peace of mind, because we do want people to feel safe. I mean, we have a really strong track record with hundreds of reviews. Nobody has ever referred to us or made a comment of us taking their ideas, so I can say that. Nor have we ever. But there's no record of it. You can search night and day, you will not find. At least not that I don't. But yeah. I mean, so I'm trying to. This comes up a lot, and I'm just curious. Like, what are your thoughts from the other perspective?
There's no doubt that a lot of inventors are skittish. There's no doubt that a lot of inventors don't trust people. And battle of the forms is a problem. I got mine, you got yours. Well, which one do we use? My NDA is pretty good. It's a mutual NDA, so both sides respect the others, whatever they're disclosing. But you're right. I mean, we have the state bar makes me tell clients all kinds of things, and there's certain things that we've figured out over time that we have to make sure we're protecting ourselves from situations. So we have a 1-page retainer agreement with 17 pages of standard terms. The standard terms are there to protect us and the client. But you know what? It's not really negotiable. It's not something that I want to discuss with clients. I don't want to spend a lot of time. And I have sometimes some lawyers that feel like they have to prove they're valuable, and they'll come back with edits. And I'm like, this is why we call it standard terms. And like you say, take it or leave it. If not everyone's a good fit for us. Not everyone's a good fit for you. Sometimes it's just, trust goes a long way. But if you don't want to sign my form, then, I'm not sure I can help you. It's hard because you want to be cooperative. You want to get business, and maybe it's going to be a really good client. But sometimes it's just a matter of assuring them. Like you just said, nobody's ever accused us of stealing an invention. We never have. We've never violated it. No one's ever said that's pretty impressive and rare. And that's important because that's probably your biggest marketing piece. That's your biggest selling point. You guys are not only honest, but nobody's ever said you're not. And that's important. That would give people confidence in signing an agreement. What I find when I send clients to big companies, and I've seen this over and over, big companies often have it's basically a disclosure agreement. And it goes like this. If you have a patent, we will respect your patent rights. If you don't have a patent, anything you show us might be something we're already working on, and we feel free to use it all we want. Well, I always tell my clients, don't sign those agreements, because basically you're giving them permission to steal from you. But that's what big companies will sign, and they don't want unsolicited inventions coming in. They don't want somebody coming in and showing them the next billion-dollar invention, because they don't want to get sued for violating some part of an NDA where they were already working on something. But the reality is that they're not willing to commit that they're not.
Well, it's it's definitely tough because there's industries, um, like for whatever reason, we probably do around 50 plus products a year, and we'll have 4 or 5 in multiple industries that are all overlapping. Like pet products, we get a lot of water bottles for some reason. We get a lot of certain types of nursing equipment. Like there's certain industries that what's the other one? Oh, hair.
Yes.
We get like a
Hair
million
products. Hair
hair
products. Yeah, we all
products.
care about our hair way too
Um,
much.
what's another like cord management? Like there's just like weird niche industries you would not expect, and people just like coming in droves on those. And I will turn down projects if I think they are going to conflict, or I'll ask permission from the other inventor first, typically. Um, but it is tough because at the same time, the NDA is before any business has transition has there's no any transactions taking place. And I too do not want to pigeonhole myself out of a project, because typically if you're trying to design something, somebody else has. But I will say on the other side of that, when I have had somebody come to me with the same idea in a smaller package, I, even though I didn't have an NDA on that project, I'm still actually developing it right now. I told the inventor, I said, hey, there's another client or another person that's requesting I build this. Do you have an issue with it? He said, yes, I do. I said, that's great. I respect that. I went back to the other clients. So like, I can work for you, but not on this project. And we did another project together.
And that's fair. That's fair.
But it's like you say, it's something that like I want to always be, regardless of the legal aspect. I mean, I want to protect myself legally. Regardless of the legal side, I want to be as fair as possible to our clients, and our goal in our stance has always been not to make money, but to create, just to solve a problem in a meaningful way. Like we're trying to actually do things and make, we have satisfaction guarantees, and like we push out all the time, because I don't want your money if you don't feel like we've earned it. And like, but at the same time, we want to protect ourselves and not get stuck in legal stuff, because it's not what I know, it's not what I'm good at, it's not what I, as much fun as you are to talk to, it's not what I enjoy. So um you know and we're getting a little off topic, but I'm just curious, like where do you see a fair balance of how to structure ourselves so that we are both, making the most of our resources and, creating a really good environment for our clients?
It sounds like you're doing it right. It sounds like you're doing it the same way I do, which is you run the conflict check, you make sure nothing's too close, and then you tell people if it's close enough that you're worried. But then at the end of the day, it's their decision. And you really, not everyone's going to work. But it sounds like you're doing it the right way. It sounds like you've figured out that, as long as you're honest and you're doing a good job for people, that they should be honest with you. And unfortunately, some people are just they can't get out of their own way. They're just too neurotic or too skittish to be able to actually do a deal. You can't help those people. Send them to a psychiatrist, but you can't really do business with them, because if they're not going to trust you after all you've shown them. I have people who want me to sign a non-disclosure agreement, and I'm like, I can't do that. What do you? Well, you're hiring me to file a patent application. You're literally hiring me to disclose your technology to the government and all the world. How could I sign an NDA, a non-disclosure? Now, I have licenses from the state of California, state of New Jersey, the Patent and Trademark Office, 15 federal courts around the country. I got a lot of ethical obligations not to rip you off, but I cannot sign an agreement that says I won't do the exact thing you're hiring me to do. And same thing with you. You can't really do an NDA as true NDA, because again, you're making products for people. You're making something intending to be seen. Now, that doesn't mean you won't, without their permission, take the thing. But people don't understand. Lay people don't understand what they're asking us to agree to when they ask us to agree to these things, because they're literally hiring you to show something to the public.
Well, I'm glad you said that, because like we have a pretty big team that we use now. We have over 50 trusted individuals that we work with, and these are relationships that we've established over years. But in order to get your product to market, it's not just us. It never is just us. It's um, and in our NDA, it discloses our team as part of the protected group. which is one of the reasons. But also, we've been in a very similar situation where we did some promotion material for somebody. They approved it. It was a multiple team effort to do this promotion. This was years ago. They approved it. They reviewed it. They iterized on it, and then they came back years later and so we want you to sign this NDA and take it down. Like, I don't even have control over this information anymore. And I talked to my attorney about it. He's like, absolutely, you do not sign that NDA.
You've heard the expression closing the barn door after the cows have gone out, right? Signing an NDA after you've disclosed is literally useless. It has no legal force or effect, and it's too damn bad you didn't have me sign it earlier, because once you disclosed and I didn't sign, signing later doesn't matter.
Well, I guess the part that was really rough was like we chose them to promote their business. Like, we actually like had an opportunity to promote a client, and it was this college student. I don't want to get into details, but she was just a wonderful person, and I was really excited to do it for her. And then just to see how it flips around, it's like now we're in a bad light with her because she spoke to somebody and they've informed her that I don't know, whatever. I don't know how that conversation went down or what that conversation looked like, but she came back pretty furious. And this is not months later. We're talking about probably 3-4 years later. It's like, I haven't tracked where that article went. I don't even know. I don't remember who the publisher was at this point. Like,
people sit on their rights for a long time, then they try to enforce them, and it's just too late.
Yeah.
Let's bring this back to my last lightning round question that we got off track for. What's one old school strategy that still works today?
Notice. Put a copyright notice on everything you put out. The running footer on the bottom of your website. Put a TM or an SM. There's 30. Well, we're not going to get into details. But if it's a trademark for goods, put a TM. If it's a service mark, put an SM. Don't do the R in a circle till you get the registered trademark. Put a C in a circle on everything you do. And if it's patent pending, say patent pending. If you have it patented, put the patent number there. But mark it with notice. Tell the world, I claim rights in this. Put the sentence, all rights reserved. Tell people that you're claiming rights, because failing to do so will often prevent you from getting damages later. And again, the innocent, honest infringers might stay away, and you'll have less competition from companies you care about.
That's great.
Perfect. All right. Well, lastly, where can people get a hold of you?
And Mark at hpl.law, MARC at hpl.law. And come onto our website. We got a form, fill it out. We'll get back to you right away. My cell phone, I'll give out to clients. I'm not going to put it here, but I'll give out to my clients. It's on my business card. Happy to have you call me anytime, day or night, if I can help. But we're very responsive to our clients, and we love helping people.
Yeah. And so you'll be able to find that in the description if you're on YouTube. And if you're not on YouTube, you're probably not seeing this. So like, subscribe. And if you have a product you want to develop, come talk to us at My Product Developer. And if you want to protect the product that you're developing with My Product Developer, go to Mark Hankin at HPL Law. Is it HPL.law?
It is HPL.law.
Wow. Okay. I don't think I've seen the .law before.
Yeah, we had a .com. It's HankinPatentLaw.com, and spelling that takes forever, and people get it. So we went to a shorter email.
I like it.
HPL.law is amazing.
Yeah.
All right. Well, anyways, thanks for joining us, guys. Have an amazing day, and come join us on the next conversation.
Thank you, Joel, Brandon. Great to see you.
Hey,